The Supreme Court has refused an application by the Firearm Licensing Authority, FLA, seeking disclosure of an investigative report prepared by the Integrity Commission concerning alleged corruption, impropriety and irregularities in the storage of firearms and ammunition and the award of firearm licenses at the authority.
In a ruling delivered by Justice Tara Carr in Chambers, the court determined that the report remains confidential under the provisions of the Integrity Commission Act until it is formally tabled in Parliament. In refusing the application, Justice Carr held that the court already had sufficient information to determine the issues arising at the leave stage, and that disclosure of the report was therefore unnecessary at this point in the proceedings. The court found that the FLA was already aware of the nature of the investigation, the decision makers involved, and the grounds upon which it intended to challenge the process, including allegations of procedural unfairness and illegality. Justice Carr stated that the judicial review proceedings are primarily concerned with the decision-making process of which the applicant was already aware. The court further held that the Integrity Commission had satisfied its duty of candor by providing sufficient information regarding the investigation and the process undertaken. Justice Carr also rejected submissions that the report fell outside the confidentiality provisions of the Integrity Commission Act. The court concluded that reports prepared pursuant to Section 54 of the Act remain subject to the confidentiality requirements imposed by Section 53(3) until they are tabled in Parliament. The judge noted that the legislation expressly criminalizes unauthorized disclosure of confidential investigative material and held that it would be inappropriate for the court to order disclosure in circumstances where Parliament had prescribed a clear statutory process governing confidentiality and tabling. Accordingly, the court refused the application for disclosure. The court granted leave to appeal the ruling. The substantive application for leave to apply for judicial review is scheduled for hearing on September 17, 2026. Janella Precious, TVJ News.
In the meantime, the attorney representing the FLA says the decision will be appealed.
The decision of the court today can be summed up in two sentences. One, the court believed that although we're challenging the report, it is not necessary for the purposes of granting leave to apply for judicial review. And two, that the court believed that the confidentiality clause in the Integrity Commission Act, particularly, I believe it is Section 53, subsection 3, and Section 56 generally, precludes the disclosure of the report. But however, we argue that that interpretation is not correct.